My lords and ladies, I'm going to address you briefly on the breach of Malaysian company law. And the appellant's case here is that when Realty issued the 2.75 million new ordinary shares with a nominal value of RM1 each in connection with a conversion, it issued those shares at a discount in breach of Section 59 of the Malaysian Companies Act. The respondents dispute this. They say that 550,000 ringgit had already been paid by STIC to Realty when the CPS were issued in August 2004. They also say that that sum could now be appropriated to the payment required for the new ordinary shares. And thirdly, they say that a further 2.2 million ringgit was paid to Realty in cash on the 8th of April 2013, which was the day the ordinary shares were issued, bringing the total to 2.75 million ringgit. So there are 3 points in issue. The first one is, was 550,000 ringgit paid in August 2004? The second is, was 2.2 million ringgit paid in April 2013 as a top-up payment? And thirdly, could the 550,000 ringgit, if paid, be appropriated to the amount payable in 2013? And it's common ground between the parties that if the answer to any of those three questions is no, then the shares were issued at a discount in breach of the Malaysian Companies Act. Now, in relation to the first and second questions, we do not say that there was no evidence that on which the judge or court of appeal could have based their decisions. What we do say is that there were so many factors the first instance judgment didn't take into account that it shouldn't be allowed to stand. And in particular, on the 550,000 said to have been paid in 2004, the first instance judgment gave no reasoned decision at all, and in fact gave no indication that the issue was in fact live between the parties. So we say that what the Court of Appeal judgment ought to have recognized was that the findings below couldn't reasonably be explained or justified, and by failing to recognize that, fell into the same error. In other words, we say that neither judgment below has earned the due respect of the appellate court. Now, in relation to questions 1 and 2...
Just pausing that, Mr. Bellingham,
yeah.
Is there a fourth question, which is even if the light goes on under 1, 2 or 3, what's the consequence of a breach of Section 59?
Yes, there is.
And in particular, is this a consequence designed to protect Realty, or is it a consequence for the affairs of the parent company?
Yes, that is an issue as well, and I'll address your lordship.
Because I think the courts below were against you on that.
Certainly the Court of Appeal was yes. At paragraph 132. That's correct, Mike.
So that even if you were right about the earlier points, it didn't colloquially butter any parsnips.
Yes, that is the fourth issue that needs to be considered. Just on the first and second issues, all I'm going to do is refer you to our written case at, first of all, paragraphs 82 to 83 on the first issue, which is at page 9324, and at paragraphs 86 to 88, which is at page 9327. And both of those make appropriate cross-references to our written closing submissions following trial. The only document that I am going, or the only item of evidence that I am going to touch on very briefly, and it's in connection with a 2.2 million ringgit payment said to have been made in April 2013, is that the respondents and the judgments below relied heavily on a document called an official receipt, which is a document purportedly issued by Realty to STIC on the 8th of April 2013, recording the receipt of 2.283 million odd ringgit from STIC. That document, just for your reference, is at page 3979. And what happened in relation to that was that the appellant formally challenged the authenticity of that document. Her notice to prove is at page 269. But A, the defendants didn't prove the document. B, my learned friend didn't once refer to the issue of authenticity in his submissions at any stage, and hasn't in his current case. C, no respondent witness gave witness statement, evidence, or testimony on the issue of authenticity. And D, the first instance judgment didn't even consider the issue of authenticity, and nor did the Court of Appeal judgment, which instead concluded at paragraph 114 that the judge must have considered the point, but then moved on and didn't consider it itself. And perhaps the most interesting aspect of this story is that when Maples, the solicitors for the respondents, were asked to provide two things. They were asked to provide metadata of the official receipt, which of course at that stage was still quite a recent document, purporting to be dated the 8th of April 2013. And when they were asked for a copy of the covering email or fax by which it was sent from WTK Realty to STIC, the answer in a letter dated the 20th of September 2017, and the reference to the important parts of that letter are at 7224 and 7225, was that the claimant was free to inspect the original and therefore completely ducked the metadata question. And also, as to the request for the covering email or fax, they said it was sent by courier. And in my submission, that should have set the alarm bells ringing. And instead, the courts below simply accepted the document as evidence of the truth of its contents. I'll now move straight on to the third issue, which is whether the 550,000 ringgit, if paid in August 2004, can be credited to the amount payable in 2013. So far as this issue is concerned, we're effectively in first appeal territory, and the reason for that is that the first instance judgment reached a completely unreasoned conclusion, simply preferring the respondent expert's testimony to that of the appellant, and so the Court of Appeal considered it afresh. And really the issue boils down to two questions. The first question is, what actually happens to the CPS when they're converted? And there was quite a lot of common ground on this. Both experts agreed that the CPS do not mutate into ordinary shares. They're not reclassified. They're not subdivided. They're not consolidated. The new ordinary shares are different shares, and they're not the same shares as the CPS with altered rights. And just to refer you to the respondent expert's testimony on that, you'll see that at page 8250, where he accepts that.
8350?
8250.
250,
8250. Now, the essential difference between the two experts on that question was that the appellant's expert said, and I'll come back to his reasons in greater detail in a moment, he said that the CPS are redeemed when conversion occurs, and immediately thereafter, new ordinary shares are issued. Whereas the respondent's expert said that the CPS are surrendered and therefore extinguished. Those are the words he used, surrendered and therefore extinguished. And one sees that in his supplemental report at paragraph 17, which is on page 2589. And I'll come back to these slightly different views in a minute. That was the first question. The second and more important question, perhaps, is when the CPS are converted, whether they're redeemed or extinguished as part of that process, can the original subscription amount be returned to the holders of the CPS so that it can be effectively redeployed as subscription monies for the new shares? Or can that only be done if there's an authorized and confirmed capital reduction? Both experts, again, agreed substantially on the answer to this. They agreed that when the CPS were issued back in 2004, the 550,000 ringgit, if paid, formed part of the issued share capital of WTK Realty. And you see that in paragraph 12 of Mr. Srinivasan's supplemental report, respondent expert supplemental report, at page 2588. They also agreed that the memorandum and articles tell us nothing about how the 550,000 ringgit paid on original subscription falls to be treated when conversion takes place. They also agreed that the subscription agreement itself doesn't tell one the answer to that. There's no right under the subscription agreement for the 550,000 ringgit to be paid back. And one sees that at pages 8236 and 8238, where the respondent's expert agreed those points. And in particular, neither of the two contractual documents, the articles, memorandum and articles and the subscription agreement, gives STIC the right to reimbursement of the 550,000 ringgit when conversion takes place. And we say that would be odd if they did have that right, given that it forms part of the company's issued share capital. The experts also agreed that WTK Realty is a creature of statute under the Malaysian Companies Act 1965 at the Material Times. So to understand how it can operate and what it can do, one must look to the statute. And he accepts, the respondent's expert accepts that at page 8240 and 8242. And this is where they diverge. The appellant's expert says this: what happens on conversion is that the original CPS shares are redeemed and new shares are issued. And the reason he says that is that the statute makes no provision for convertible shares as a freestanding concept, but does make provision for shares that are redeemable under Section 61. And so the process labeled as conversion involves the redemption of the CPS and the issue of the new ordinary shares. And importantly, when redemption occurs, that must either involve a confirmed reduction of capital, or failing that, the issued nominal capital, which is the 550,000 ringgit represented by the CPS, must be transferred to a capital redemption reserve, where it's effectively treated as part of the company's issued share capital. In other words, it's not available for distribution. And you get that once you're in redeemed share territory, which is the territory of Section 61 of the Act. You get that from subsection 5 of Section 61 of the Act. If I could, I'll just give you the reference to the Malaysian Companies Act for your note. It's at page 1977. And you have Section 59, Section 61 there, and you also have Section 64, which deals with capital reductions. So that's what the appellant's expert said. That was his reasoning in his report, and we say he stood by that in his oral testimony. The respondent's expert, by contrast, said there was no redemption, and the reason he said there was no redemption of the CPS is that a redemption only occurs where the company makes a cash payment for the shares that are being redeemed. So that was effectively the battleground between the two experts. We say there are three clear errors in Mr. Srinivasan's reasoning. Error number one was his statement that or his opinion that the main reason which he gave for saying the CPS cannot have been redeemed is that WTK Realty didn't make a cash payment for it. But he did not suggest that consideration in a form other than cash payment was not provided here. Needless to say, consideration was provided by the company because the surrender of the CPS by STIC, the surrender of the CPS with its potentially very valuable preferential rights to dividends entitled STIC to subscribe for very valuable ordinary shares by paying only par value. I said consideration moving from STIC, sorry, it was WTK Realty that provided consideration. So he didn't suggest...
So when you say the company, instead of cash payment by the company, you mean the company there being Realty? I
mean Realty, yes. Sorry for that confusion.
So what did the expert say happened to the nominal amount of the prefs?
Well, the nominal amount, he said, could simply be transferred over as part of the new nominal amount represented by the 2.75 million ordinary shares. Yeah. Without a reduction, without going through the hoops of a reduction of capital.
But would it go through capital redemption reserve?
No.
And be capitalised there?
No, it wasn't capitalised in that
way.
And one sees that from the accounts, and I'll give you the references to the accounts in a moment. It was simply removed from the from the balance sheet and resurfaced, but without going through the hoops of a capital reduction.
Well, resurfaced where?
In the issued ordinary share capital ascribed to the 2.75 million new shares.
I'm sorry, can you just describe what you say was the first obvious error?
The first obvious error is that he said they cannot be redeemable shares, or those shares weren't redeemed, the CPS weren't redeemed. That's not how one analyzes it, because a redemption must involve payment of cash.
By Realty.
By Realty, yeah. And that didn't occur. There was no payment of cash by Realty.
So that means cash in ringgits, physical money.
Yes, yes. And he said what that means is the CPS are not, you can't analyze the process of conversion as a process whereby you first have redemption of the CPS and then the issue of new shares. And accordingly, that's not what happened.
So there wasn't a redemption either?
That's his analysis, yes.
So the shares the CPS are still there?
Well, that is what we say was the obvious error in his reasoning. We say it must be that they were redeemed. This is what the appellant's expert said. They must have been redeemed. And as soon as they're redeemed, you trigger this requirement of either having a capital reduction or the money or the nominal issued share capital represented by those shares before redemption has to be moved across to a capital redemption reserve.
Or it has remained, despite what the accounts might say.
Yes, but
it was not dealt with in a lawful manner.
Yes.
An unlawful reduction of capital, I think there was.
Yes, yes.
But it was you who were saying that they had been redeemed and new shares issued rather than extinguished.
Yes, yes.
Right. So you say that the CPS can only be redeemed if they're being given back, but you say they weren't redeemed because there has to be cash considered.
No, that was the respondent's expert's analysis. The appellant's expert was very clear. He said that the proper way to analyze this is that there's been a redemption of the CPS and then an issue of the new shares.
And is that what the Court of Appeal accepted?
No. It said at paragraph 131, they said, having considered the printed material before the court on the issues of Malaysian law, we prefer the reasoning and conclusions of Mr. Srinivasan, that's the respondent's expert. We do so mainly because of his conclusions about the basic principles of convertible shares. He made the important distinction between convertible shares and redeemable shares. There was no reduction of capital by the conversion, which is the mischief Section 59 is aimed at preventing. So we say that was his first main error. And he was taken to a 1999 English authority called Re BDG Roof Bond Limited, a decision of Mr. Justice Park. And that decision held that shares can be redeemed for a payment other than cash. And accordingly, there was no basis for saying that just because cash wasn't paid on the redemption of the CPS, they can't therefore logically have been redeemed. He was taken to that at page 8292 of the transcript. And his answer was that he was hesitant to commit to that case being correct because he hadn't considered it. Instead, he relied in his supplemental report on an Australian decision called Re Arrowfield Group Limited, and that held the opposite. That held that for a redemption of shares to occur, there has to be a cash payment. But the judge qualified his judgment in two important respects. First of all, he said he'd been given insufficient time to decide it because it was a live transaction hearing and the parties needed a decision almost immediately. And he twice said that he was pressured into having to give his decision without having enough time to reflect on the nature of preference shares.
Is the judge in Arrowfield.
In Arrowfield, yes. And the reference to that, it's not in the authorities bundle, it's exhibited to the expert report, is at page 2612 and 2616. And he also said that at least one definition of redemption was to recover by payment or other satisfaction. So the judge himself expressed doubt on the correctness of his conclusions. So it hardly provides the firmest foundation for the respondent expert's opinion. What happened at the Court of Appeal hearing was that the Respondents' Council placed additional reliance on a second Australian case, which was one of the HIH insurance cases, and that wasn't considered by either side's expert. It follows Arrowfield on the narrow question and says that for a valid redemption of convertible notes in that case, there had to be a payment. But on the wider issue of the case, in fact, it supports the appellant's expert analysis because the judge concluded that the conversion of the convertible notes into ordinary shares in that case had to involve a two-stage process: first redemption, and then immediately upon redemption, the issue of new ordinary shares. And that authority, just for your record, is at 12328. And the relevant paragraphs are 24 and 57.
24 and 57.
24 and 57. And that, my lords and ladies, was also the analysis adopted by Mr. Justice Simmons, as he then was, in the English case of Rees and James's Court Estate, which is at page 13114. And counsel there had raised exactly the same argument that Mr. Srinivasan was making here, which was that, in effect, the capital would not be reduced by reason of the conversion. And the judge rejected that. And again, Mr. Srinivasan was taken to that during his testimony. You see that at page 8298. And he said that the case could be distinguished because in that case, the shares into which the existing shares were being converted were redeemable preference shares. And we say that there's no logic to that at all. And it's clear that he didn't really have an answer to it. And you see that at page 8300. So that was his main error. A further reason he gave for saying that the CPS can't have been redeemed was that he ultimately accepted that a redemption can occur where a company pays for the shares otherwise than in cash, which clearly contradicted what he was saying earlier. And then he immediately added that the company must provide the relevant consideration from its own assets. So he added a new requirement. You see that at 8262 and 8264.
Which judge is this?
This was the expert again, sorry, the respondent's expert.
So the page was
8262 and 8264. And we simply say there was no logical reason at all for that extra requirement. Under the general law of contract, consideration must move from the promisee, but there's no requirement that it must come from his own assets. But in any case, the right to subscribe for new ordinary shares is a right that's incidental to the ordinary shares, and that, by definition, represents a share of WTK Realty's assets. So the requirement was completely illogical. And then the third reason, the third error that he made very, very quickly was that he clearly accepted that the process of conversion involves an exchange of one class of shares for another. And he referred to shares being extinguished or cancelled. And if they're extinguished or cancelled, how can it be that there is no requirement for a capital reduction? In other words, there is a capital reduction, but how can it be that there's no requirement for that capital reduction to be authorized and then confirmed by the court? And that leads me on to the fourth issue, and that's very briefly the significance of the breach of the Malaysian law issue. My learned friend says in his case at 148 that a breach of Section 59, if established, has nothing to do with the affairs of STIC. We say, in fact, and passing over the point that group companies should not be obviously viewed in isolation, that STIC has surrendered its CPS without having lawfully subscribed for shares in WTK Realty. And a breach of Section 59 meant that the conversion was liable to be set aside under Malaysian law. That was the evidence of Mrs. Ma's expert, and you see that at 8078 and 8085. And instead of crediting the $550,000 to a capital redemption and reserve, the respondents caused that amount to be appropriated towards the payment due by STIC, and by doing that, they allowed an unauthorized reduction of capital in breach of Section 64 and a repayment of the $550,000 to STIC to which it wasn't entitled. As my learned friend Mr. Crowe has said, unlawful conduct in itself renders prejudicial conduct unfair. And one gets that from Saul D. Harrison.
Well, we're now what? How many years on are we from this impugned transaction?
8 years.
8 years.
Yes.
And has Realty sought to set it aside?
Well, it's seeking to set it aside as part of the relief sought in these proceedings.
No, I'm sorry. I thought you said this affects STIC because an unlawful issue of shares or a cancellation without a proper reduction of capital could be set aside, presumably by Realty.
At the suit of Realty. At the suit of...
Yes.
Yes.
No, that hasn't happened.
No.
There hasn't been a suit, no.
But then,
But we say that for the purposes of Section 184I, the claim is not being made under Section 59 of the Malaysian Companies Act. The claim that is
You're
being
just saying
made
it demonstrates an unlawfulness.
it demonstrates unlawful conduct.
Well, I thought you were saying something a bit more than that. You were saying that there is sort of prejudice to STIC because it exchanges pucker preference shares for ordinary shares which are at risk of being taken away. But if they were, I mean, what would have happened if Realty had tried to set aside the conversion on the basis that there had been an unauthorised reduction in capital? Would they have had to give them back the CPS?
Yeah.
I mean, they can't just set that aside and not give STIC anything.
Well, what
What would have been the relief if that challenge had been made and succeeded?
I think the way we look at it is to say that what should have happened in this case. What should have happened is that a capital reduction should have occurred. That requires a special resolution to be passed on 21 days' notice, which would have enabled my client to block the entire transaction, which is the subject matter of a complaint in these proceedings. And even aside from that, she would have had a chance to block it in the court when it came up for confirmation.
Well, that might be something unfair to your client as a shareholder, quite separately, as a shareholder in Realty.
Yes.
But it's hardly unfair to her as a shareholder in STIC, is it?
Well, it is, because
the worst. It's simply, as my lady's just said, exposed STIC to the possibility that the conversion wasn't effective, so that they never, in fact, lost their prefs.
It's unfair to her as a shareholder of STIC for two reasons. One, it deprived her of the opportunity to block the conversion.
But not as a shareholder in STIC.
As a shareholder in WTK Realty, that's
yes.
right. But the wider point is that unfair prejudice done to one group company can form the complaint of an unfair prejudice claim in relation to another.
I can see it can.
company.
I mean, if one is a subsidiary of the other and it damages the affairs of the subsidiary, it may adversely affect the parent. But in this situation, the Section 59, as I understand it, is there for the protection of the outside creditors of Realty against an unlawful reduction in capital, and therefore an exposure of them to not getting their money back because the capital's been unlawfully reduced. It's about maintenance of capital.
It is about maintenance of capital, but it's also about a fundamental alteration to the balance sheet of the company. And yes, it is to the balance sheet of WTK Realty,
Yeah.
but that doesn't prevent a shareholder in the parent company complaining.
Okay.
So, I'm sorry, if I need to ask a question. The monies used to redeem the CPS were otherwise than out of distributable profits, is that right?
Yes.
So that an amount equal to the nominal amount of the shares redeemed should have gone to capital redemption reserve.
Yes, that's right.
And then that could be used in paying up fully paid bonus shares.
That could be, yes, but then you would need to go through the hoops of a capital reduction to do that.
Why? It says it may be when you just capitalise the reserve.
I think that's the effect of Section 61(5).
And 7.
And 7.
So the effect of that is that the capital account is not diminished to the prejudice of creditors, my Lord's concern. The redemption doesn't reduce capital, because that's what the section says. And then you take a sum equal to the amount of the nominal amount of the shares redeemed to capital redemption reserve. It's in a new place, a capital reserve, though you haven't given us, I think, all the provisions which apply to the capital redemption reserve. And then you capitalise the capital redemption reserve.
Yes, but
so far as it's adequate for this purpose.
in order to do that, other than when it's reissued to members as fully paid bonus shares, the sum can only be taken out of the capital redemption reserve with a capital reduction under section.
I was just querying whether that was so if you utilise subsection 7, but let's leave it there.
Thank you.
I think we're back to you for, I think, 10 minutes or so.
I'll have to use them wisely. The point we have now reached is the tail end of our second main issue, which was that there has been any one of three things that has happened which constitute unfair prejudice even without equitable considerations: loss of substratum, unlawfulness. Final heading is a justifiable loss of confidence. To a large extent, that's parasitic on what has gone before. The only thing that we would urge on you is that my learned friend has sought to argue that justifiable loss of confidence is a concept which is confined to quasi-partnership companies, which it's not. And secondly, that it is confined to cases involving functional deadlock, which it is not. And if I could, as a lazy shorthand, simply give you two paragraphs of and I've mentioned it before, it's a recent Jersey Court of Appeal judgment, FTV against ETFS, paragraphs 271 to 272, page 12143 in our bundle. That provides an analysis of the case law that has been deployed, John Locke and John Blackwood, Westbourne Galleries and Lau Chu, and our submission is that justifiable loss of confidence does not only arise in relation to, it is not a basis for winding up only in relation to quasi-partnerships, and it is not a concept that is limited to situations of functional deadlock.
Are you accepting that this is not a quasi-partnership?
No, for the purposes of this part of my argument,
right.
I'm proceeding on the basis that you may not be with me on my first main point. So this whole section on loss of substratum, unlawfulness, and justifiable loss of confidence proceeds on the assumed basis that you may not be with me on.
Your justifiable loss of confidence case isn't based on the unlawfulness, is it? It's just quite separate and freestanding.
Yes.
Yeah.
So who has to lose confidence in whom? Are you in one of
The
these family companies that you've been describing? If one member of the family loses confidence in the others, does that then mean that that member is entitled to wind up the company even if the others remain confident in each other?
I think the answer to that is always going to be context specific, in the sense that if there were 100 members and one did not have confidence in management, that could well not be a sufficient reason to wind up a company. But where here you have essentially three branches of a family, and one of the three branches has fundamentally fallen out with the other two, if there is a justifiable loss of confidence of that degree at that level in a family group, that's enough. Could I then move on to the third and final point in the time remaining, which does involve a challenge to primary findings of fact by the trial judge, which were to a substantial extent upheld in the Court of Appeal. To be clear, if the approach that you take is that you won't interfere if there was some evidence to support the findings below, then I lose. But what we do submit is that if you look at what is said in the Bank of Ecuador case, particularly paragraphs 4 to 8, the practice, the self-denying ordinance, as you described it, is not, in the language quoted in Central Bank of Ecuador, is not cast in iron. And you do have to examine what has gone on. What did happen in Central Bank of Ecuador is that the Privy Council actually made findings of a want of probity on the part of the directors in question, despite concurrent findings of fact to the contrary in the courts below. We are not going anywhere near that far. We are merely asking you to readdress the question of proper purpose. It is perhaps not irrelevant to point out that the trial judge in the Central Bank of Ecuador case, which prompted this board to take a different view on the facts, was the same trial judge as in our case. The other authority which we mention in our written case, which we do urge on you, is Harb and Aziz. Paragraph 39 makes the point, and it makes it very neatly and in our submission very powerfully. Paragraph 39 is page 12276, which is, yes, appeal courts give credit to first instance judges because first instance judges have the opportunity to assess credibility and to review all the evidence. But they are entitled to respect if they have earned it, and they earn it by demonstrating in their judgment that they have taken advantage of that opportunity. And if, as we say has happened in this case, the trial judge has not earned respect by considering the relevant evidence, then his judgment is not entitled to respect in the higher courts. And there has been in our submission, and I can rattle through extremely quickly, a litany of points going to proper purpose which are simply not addressed in the court below, in the trial court, and the position was simply not addressed and remedied in the Court of Appeal. The first, essentially, is just the chronology. I invite you that, as an appendix to our key documents bundle, there is a chronology. I'm not going to go to it. It starts at page 9271. Just look at the dates. In our submission, it is perfectly obvious that within a matter of weeks of WKN's death, his older and younger brother simply seized the opportunity for a bit of a palace coup, so to speak, and grabbed control of WTK Realty. The coincidence of the death, the conversion, and the issuing of the OS 39 proceedings in our submission is stark and obvious, and it is not addressed. The trial judge doesn't even mention the issue of the OS 39 proceedings, the coincidence between the attempts by the two brothers to overturn WKN family's majority control through OS 39, the Malaysian proceedings, and the conversion, in our submission, is stark and obvious. It should have been addressed, and it is simply not adequate to ignore it. The other list of issues, I'm going to have to do this very fast, but they are important points. They're covered in our written case, but I wanted to itemize them and get them in your minds orally. The whole conversion was said to be prompted by this offer from AmBank of replacement overdraft facilities. If you look at the AmBank offer, it could not be accepted in late March, early April. It's page 3818.
Is this because of the required guarantee?
There was a required guarantee which Neil had said he wasn't going to give. And the AmBank offer said, we require you to raise your issued share capital by 2.5 million to 19.45 million. The conversion didn't achieve that. The conversion only raised the issued share capital to 19.15. The AmBank offer is a pretext. It could not be accepted. It cannot justify the conversion. Second point, if you look at the AmBank offer, it did not require the issued share capital to be increased until June of 2013. Why did it have to be rushed through on the 8th of April? Answer, because KY and KC wanted to make sure that they issued ordinary shares in WTK Realty before my client had got a grant of probate. Why else would they rush it through months before they needed to? Again, simply not addressed. The question of timing is simply not properly addressed. Did WTK Realty actually need overdraft facilities at that time? There is a passing reference to the evidence in the Court of Appeal's judgment, but no analysis of what evidence they're talking about. And we would invite you to look, with the greatest respect, at the cross-examination of KC for a few pages, starting at 7782. And buried in there, can I take a bite of 5 minutes out of my reply, just in order to finish this without babbling like a racecourse commentator? The Court of Appeal's dealing with this particular issue of whether or not WTK Realty actually needed overdraft facilities at the time contains an error of law. I'm not going to go to it, but if you look at para 101 of the Court of Appeal judgment, what they say is that the court doesn't second-guess commercial decisions. So it was saying the court was entitled not to consider whether overdraft facilities had to be replaced there and then. With the greatest respect, that is exactly an abdication of what, in Howard Smith and Ampol, the House of Lords said you should do. Because if shares have been allotted, as they were in Howard Smith and Ampol, and there was an imputation that they had been allotted in order to affect the shareholder voting balance at general meeting level, the court is required to scrutinise whether objectively there was a need to raise finance. The reference to Howard Smith for that particular proposition is page 12361 at letter F. The court ought to consider objectively. In this case, the court didn't do it, and it abdicated its responsibility to do so on the basis of an error of law, thinking, oh, well, this was a commercial decision, it's not for us to second-guess it. It was precisely the question of whether it was a commercial decision that was the issue in the case. The other points that we made in large part in cross-examination and in closing is that if there was a need to increase the share capital of WTK Realty, there were alternative options open. There was no consideration given to those at the time by the other directors. They simply jumped ahead with the conversion. We say the obvious reason being the conversion achieved the result they wanted, which was the change in the voting power. We said that that is equally obvious from the fact that neither WKY nor WKC asked the Chief Financial Officer, Janice Ting, for any financial information about the company. She said, we need to replace the overdraft facilities. Let's do it by a conversion. There was no request by KY or KC for any financial information from her indicating what the financial needs of the company were. If the company is going to convert its share capital if STIC is going to convert its share capital, if WTK Realty is going to take on new financial facilities, the directors would have asked for financial information if it was a genuine commercial decision prompted by the financial needs of WTK Realty. There is no consideration of those points in the judgments below, and in our submission, it simply subverts the integrity of the mere conclusions, which are just conclusions, not reasoned judgments. And finally, if we could emphasize to you, go through a few pages of the cross-examination of KC. If I could just suggest some pages, 7731, 7740, 7808. He had a number of strategies. He said, I don't understand. He would answer a question that he hadn't been asked. Ultimately, it got almost farcical when, after attempting to ask a question 3 times, his response was, I don't want to be asked that question. It beggars belief, with respect, that the trial judge believed KC was a witness of truth. Justice Wallbank got it right in the incredible power case. And in our submission, this is, if you look at the cross-examination, if you look at what KC was saying, contradicting himself, declining to answer, or simply saying, disagree. Quite often, I put a proposition to him about the content of a document, and he would just say, disagree. It would be almost comical were it not for the fact that the trial judge believed him as a witness of truth. So we do urge that this is one of those very rare cases in which you should, with respect, revisit the findings of fact in the court below. As I said at the very beginning, there is an enormous amount of material in our written case which I have not addressed. We don't abandon any of it, but we've tried to concentrate on the points that matter most. And as we say, the 3 headings that we urge on you are in relation to the application of equitable considerations. The judge simply did not recognise the significance of his own ruling that fairness requires a buyout. In relation, even if there are no equitable considerations in play, there has been a complete elimination of the substratum of STIC by the conversion. There has been unlawfulness, and there is a justifiable loss of confidence in management. And thirdly, it is, with the greatest respect, obvious why the conversion was effected. It was converted in order to adjust the balance of voting power at WTK Realty, and with the greatest respect, the trial judge just didn't get it. And I'm grateful for having overrun 5 minutes. I will, as I say, take that off what would otherwise have been a half-hour reply. Unless there are any other questions.
Thank you, Mr. Crane.
I'm very grateful.
Mr. Alexander, are we to hear from you on behalf of all the respondents, or are you going to split the time?
I represent 2 of them,
yes,
which is WKY and WKC. You will be hearing from me on behalf of both of them.
I think what I really meant is
Mr. Goodison going to require some further time?
Is he?
No, I don't think he's going to require very much.
So he's just going to agree.
It would be very surprising if you wanted to make any submissions on behalf of.
He's hoping to agree with you, Mr. Alexander.
Well, I don't know. It's a question of hoping to agree with me. I just think there's not very much of a role for a company to play in relation to this sort of thing.
Thank you. Not much of a role. They've got 4 counsel appearing.
Are you talking to me, my lord?
No, I'm just observing.
My lord, on the what I would propose to do I think I have 3 1/4 hours till I think it's probably 12:30 tomorrow. What I would propose to do essentially is 3 things. Firstly, to address what I had understood to be the issues that you were going to be asked to deal with, because they are actually very clearly set out in both attached to the notice of appeal and contained in the agreed statements of facts and issues. And I may have misunderstood, but they seem to me to be rather different to the ones that have been addressed today. At the same time as doing that, I would also propose to say something about concurrent findings of fact for pure convenience, because the documents which we're going to look at give away that what is being asked here is essentially, in the main, an appeal against the judge's decisions on fact in circumstances where the Court of Appeal have effectively upheld his factual findings. So that's the first part. The second part is to deal, as a matter of substance, with each of the issues which are said by the appellant in the statement of facts and issues to be the issues that you are asked to decide. In doing that, I will hopefully demonstrate to your satisfaction that even if the concurrent finding principle is not applicable in relation to one or another fact, it doesn't matter, because in any event, on the evidence, the judge simply cannot be faulted for reaching the conclusions that he did in relation to the issues which the appellant has asked you to look at. In that context, just so you know, I will in fact be picking up, obviously, the question of the winding up of WTK Realty. The third thing I would propose to deal with is a few additional matters which, for whatever reason, haven't fallen into categories 1 or 2. That will include the order that the judge did make and whether he could, in fact, make that order. My Lord, starting with the concurrent findings, I'm sure my lords and my ladies are all very familiar with the concurrent findings principle, so I'm just going to jump straight to the fact that in paragraph 43, which is page 94 of the key documents bundle, we have set out many of the relatively recent cases in the Privy Council which deal with that principle. There's another recent case to add to that list. It's called Hussain and Ramnarine Hill.
What page 94?
Page 93, I'm sorry, did I? Page 93, did you?
No.
Yeah, it's paragraph.
That's 73?
Yeah. Yes, paragraph 42 starts. The paragraph 42 is on page 93, and then it's 94. We set out the principle.
Well, you seem to have got a completely different pagination from us, Mr. Alexander.
Of the key documents bundle.
Page 9352.
Well, would you mind giving?
Oh, I'm sorry. Do you want?
We're using a single composite bundle in the electronics.
Fine. Then I can do those numbers just as easily.
It would be much more.
No, that's no problem at all. I actually had to put the other numbers on in place of them last night when I realised that the key documents bundle had a different pagination.
Yes. We're
yes.
all using the main electronic.
No, okay, fine. There's no problem with that at all. Those are the ones I've certainly got. Paragraph 43 of our written case, which is 9352. I wasn't proposing to go through all of them. We've given you the references to the cases and indeed the specific paragraphs in each of the cases where you'll find the relevant parts. I was only going to add to that list that there is a case called Hussain and Ramnarine Hill. That is in the joint supplementary hearing bundle.
Page.
Well, now that says page 55 of the joint supplementary hearing bundle,
Yeah.
but it does not have an MS number on my copy.
Well, that's a fairly concise bundle that probably has only one lot of pagination.
Some of us remember the case.
It is, well, my lady, I was going to say the judgment was given by my lady. Lord Briggs and Lord Stevens were both part of the board in that case, and the relevant paragraphs which summarise the position in relation to the concurrent findings are paragraphs 39 to 40. Now, the concurrent findings principle, we obviously say, is of significant application in this case. As we say at 9352 at paragraph 44 of our written case, there is nothing, we say, about this case which constituted such a departure from the rules which permeate all judicial procedure as to make what happened not in the proper sense of the word judicial procedure at all. This was an extremely normal case that went through in just as one would expect, both at first instance and in the Court of Appeal. We say that as a result, there are a large number of facts. I won't go through them all immediately, but just to give you an illustration, we say there the concurrent facts, the principle applies to the fact that there was no shareholders agreement, there was no family agreement. The conversion was carried out for the ultimate or the dominant reason of replacing the credit facilities of Realty, which were about to expire. The conversion was paid for by one payment of 550,000 RM and one payment of 2.2 million RM. We have both the judge and the Court of Appeal deciding that STIC did not operate as a quasi-partnership, whether before WKN's death, which was the 13th of March 2013, or indeed after WKN's death. We say also that the concurrent findings principle applies to the fact that the holding the CPS was not STIC's raison d'etre, such that its purpose has been spent after the conversion. And we say that both the judge and the Court of Appeal found there was not sufficient evidence that the non-payment of dividends was unfairly prejudicial. They both found that the appellant had been supplied with all the information required by law and the circumstances, and they both stuck with the conclusion that WKC and Janice Ting were not dishonest witnesses, and that, contrary to that, the appellant was somebody who, and you get this at page 9354 at paragraph 4519, the appellant wanted to be an honest witness, but was challenged when that conflicted with what she considered necessary to prove her case. Now, the best way of seeing how much of this falls away is if you look at the statement of facts and issues in the case, which starts at 9247. Now, the first thing to note about this is an agreed document. It starts with the facts at paras 3 through 17, but then you go to a section describing the appellant's case at paragraph 18, that's 9255. Now, there are other places in this document where the same sort of thing is said, but if you go to paragraph 18, you also get a convenient listing of some of the concurrent findings. So, at paragraph 18.1, you'll see that the appellant alleges that STIC was a that the respondent alleges that STIC was a quasi-partnership. And then it is agreed, sorry, no, I've got it the other way around. Yes. We allege, perhaps I can just put it this way. It is recorded at paragraph 18.1 that all parties agree that this was a fact rejected by both the judge and the Court of Appeal. Mm-hmm. So they rejected the quasi-partnership argument.
A quasi-partnership in the form of a family company.
In the form of a family company. I mean, I'm going to come on to deal with both quasi-partnership in what I would call the conventional sense, and indeed what I thought I'd understood to be a quasi-partnership in the form of a family company.
But Lord Wilberforce said there are no categories.
Well, I absolutely, totally accept that there are no categories. I also totally accept that quasi-partnership is a sort of if you like, it's just a convenient phrase to describe those cases where equitable considerations arise.
Well, it does much more than that. It describes what the equitable considerations are. They're the ones that derive from the law of partnership.
Yes, my lord.
Right.
Yes.
And what are the equitable considerations to be derived when it's a family company?
Well, I think my learned friend would say that you have to read Chow Kwok Chuan in order to get a situation where you have a family company which is, if you like, described as I think actually they use the phrase akin to a quasi-partnership in Chow Kwok Chuan. And if you go to that, you get a whole series of facts that arise in Chow Kwok Chuan which simply don't arise in the present case. So, for example, if you go to or perhaps one can pick this up at paragraph 68 of our written case, which is 9360, they rely on Chow Kwok Chuan and what it's said to be its clear application on the facts. But we say that Chow Kwok Chuan didn't actually turn on this sort of principle at all. It turned on deadlock, which was described in that case as practical deadlock, and the fact that there was a three-way impasse, and because there was a stalemate. You can see that, for example, at holding 2 at 11209. You can see it at paragraphs 23 at 11218 to 11219. And that, we say, is precisely what the Singapore Court of Appeal said itself at paragraph 37 at 11225. If you have a look at Chow Kwok Chuan, you have this situation arising. In Chow Kwok Chuan, the two companies in question, they were called Chow Cho Poon, or CCPL, and Associated Limited, or ADPL, were set up by the father of the three brothers. So that's the first thing you got that comes out of this case, which led them to treat it as akin to a quasi-partnership. Importantly, that is not the case in the present case. There is no evidence that the father, whose initials were WTK, had anything to do with the setting up of STIC. The second thing that you get out of Chow Kwok Chuan, which might lead you to treat it as akin to a quasi-partnership, was that the companies were set up by the father to hold assets which had accumulated over the years. You see that at paragraph 2. Sorry, I didn't give you a reference. Paragraph 1, or MS, or 11 to 11, 11211. And for the first of those points, for this point, it's paragraph 2, still on the same page. In Chow Kwok Chuan, the father's three sons were the only directors of the company, actually both companies. So there was another factor which was taken into account where the Singapore Court of Appeal treated something as akin to a quasi-partnership. Importantly, in the present case, none of the brothers is or ever has been a director of STIC.
Weren't they found to be de facto directors?
I'm not sure they were found to be de facto directors. I don't think it was ever a finding. I think that the judge and the Court of Appeal both worked on the basis, they just sort of treated them as de facto directors. I don't think we went into, I don't think there's any actual decision in the sense of a ruling with reasons as to why that was the case. They were just treated as de facto directors. Yes, that is absolutely right. But the day jury directors of STIC are and have always been non-family members. At present, they're F.K. Low and S.F. Kwan, and Mr. Low has been a director since June 2003. So at the relevant time, he's probably the only director because S.F. Kwan only was appointed as a director on the 28th of March 2014. Another really important factor from Chow Kwok Chuan and something that's treated as akin to a quasi-partnership, the company in question has been inherited or the brothers had been endowed their shares and directorships by their parents, based on the latter's, so the parents, understanding or aspiration of furthering the family's interests cohesively. You get that from the head note at paragraph 3 at 11209. In the present case, it cannot be said that any of what happened in relation to STIC happened on the three brothers' parents' understanding or aspiration of furthering the family's interests cohesively. There is no evidence that the brothers' parents had any involvement in relation to the foundation of STIC at all.
Does that matter?
Well, all I'm doing is I'm simply identifying for you. The Singapore Court of Appeal identified a series of reasons.
You're going through the facts and comparing the facts. I have to say, I think there's limited value in doing that from my own point of view. It's the principle we're concerned with mostly.
When you're talking about the family being a quasi-partnership, I can quite see there are some cases where there's a quasi-partnership and it so happens that the quasi-partners are all brothers or brothers and sisters, and that's not coincidence, it's a family business and that's how it's run. But quasi-partnerships, as we know, they don't have to all be members of the family, they're just people who have gone into business together. But I think what we're asking you is, when that's not the case, when it's a family company in a different sense, which is not that they're all members of the family are supposed to be involved in running it, but all members of the family are supposed to benefit from it in the terms of drawing money from it or being involved in it in some way. It's not a quasi-partnership, but in the sense that the equitable considerations that arise are that they should be treated as if they were partners, but there are other equitable considerations that arise, and what I think we're asking is, what are those? Or what might those be?
I mean, from my perspective, I would simply answer that they are the factors which are identified in Ebrahimi itself as being, by Lord Wilberforce, as being, look, these are your instinctive things that give you a characteristic of whether something is, to use the phrase, quasi-partnership. For example, you might treat something as being a quasi-partnership in circumstances where you might treat it like that in circumstances where, for example, it was a partnership between two individuals and it subsequently converted into a company. I think that's the first illustration that's given there. I mean, I'm not sure you could actually sit there and say, I can identify all the attributes of a quasi-partnership. You have to look at the facts of the relevant case, and you have to say, well, do the facts of that case fit in with something that is a quasi-partnership? To which my answer for this case, for STIC, would be no. STIC, is, although you have got three brothers there, it is not a situation where it is a situation where one of the brothers created it, possibly even without the knowledge of the other two brothers, and where ultimately you get to a situation where one of the brothers dies and the shareholding is replaced by the sister-in-law, and the one thing you can't say at that stage is that there is a quasi-partnership of any description between the sister-in-law and the two brothers. I mean, the sister-in-law...
Might she not, though, have some equitable considerations that favour her? So suppose she said, well, I've got no interest in being involved in running the business, but it was always my understanding that this business would keep me in the manner to which I've become accustomed for the rest of my life and look after my children, and you mustn't run it in a way that negates that possibility.
I mean, I understand why you say that, but we haven't got evidence in this case that that is in fact what happened.
But they intended it to be a vehicle for tax saving for the family wealth.
Well,
so it's odd, isn't it, if there aren't equitable obligations between the three groups in that situation, because they all had to cooperate to utilise the company.
the only person who says that is the appellant.
But
I'm not sure you get any of the others saying that that was the reason for the creation of STIC. And what's more, when we come to substratum, you're actually going to see there are quite a lot of purposes which are actually put forward on behalf of the appellant, one of which is the one that my lady raises.
But can I just use a simple example to test your submission? Suppose that Realty was a 30-30-30, one-third each company between the three brothers, run as regular as you could be, corporate quasi-partnership. And one of them's a bit of a tax whiz and says, look, we can actually offshore some of our profits. If we set up a BVI company with its probably offshore directors, we needn't be directors of it so long as they know what to do and we tell them what to do. And we don't even need to be the shareholders. We can have a nice offshore trust being the shareholder, but it will enable us to offshore the profits. It would surely follow, wouldn't it, as night as day, that the equitable considerations that affect their relationship in the company out of which this offshore creature is created would flow into the offshore creature, because it's merely a way in which the greater purposes of their main trading company, in terms of making profits for the shareholders, are going to be achieved in a tax-efficient way.
Well, my lord,
why should they be able to, as it were, use the constitution of the offshore company as a sword or a stick to beat each other with, if they can't do that in the main company?
well, my lord, the only reason I can answer that is on the basis that that was what they intended in the first place, in the sense that they set up a structure, they set up a company with fairly comprehensive memorandum and association and articles, and at the end of the day, I mean, we haven't got any evidence from any of them in the sense that we haven't got any evidence that to say that it was a quasi-partnership and that they intended it that. What we have got is evidence from one of them saying it absolutely was not a quasi-partnership from the beginning. I mean, well, I can quite understand that each case depends on its own factual circumstances. I don't think one can go so far as to say that you can come up with some form of a comprehensive definition. All one can do is look at what the factors are in play in each case, what the evidence is in each case on the relevant company, and then make a determination as to whether or not you would say that equitable considerations apply. What I would call a quasi-partnership existed.
And should one look at STIC in isolation or in conjunction with Realty?
Well, I would say, my lord, you should look at STIC in isolation. I mean, that has been our position from the word go, that I mean, we do not have much evidence of the basis on which STIC was set up. We don't have the evidence from the individual who actually put it together, because he is obviously, unfortunately, deceased. We don't seem to have any indications in any piece of paper that STIC was intended to run anything other than in accordance with its own constitution.
Were there any documents at all in relation to the formation of STIC made available on discovery?
My lord, I don't think there were any documents available, I mean, as far as I'm aware, full stop, in relation to the formation of STIC, other than the memorandum and articles that obviously came into existence. And
Ernst Young were involved in forming STIC or advising about it?
My lord, I have forgotten precisely who was involved. I'm sure your lordship is right. But we do not have anything which sort of says, I wish to create this company for, XYZ reasons, which would enable us to form a definitive view as to whether or not it was intended to be a quasi-partnership or not. We are limited to the facts that we have.
Was there any evidence about other members of the family who were not involved in the management of the business benefiting from the proceeds of the business?
I mean, I am absolutely certain that there would have, I mean, I don't think there was any evidence, but I would have thought it must be likely that WTK Realty probably provided financial help to various members of the family, regardless of whether they were shareholders or directors. I mean, that I would have thought is natural, but I don't think we've got any evidence of that. I mean, I don't think we've got any evidence to show precisely who benefited, other than the fact that you can see the various shareholders at WTK Realty, and you can see the directors. And I'm sure the directors got paid a director's fee, and that included some of the, if you look at the WTK Realty, that included some of the members of the family who were not the three brothers. And when you get to STIC, it's only the three brothers who've ever been shareholders. No other generation has come along and joined, and at the request of one of their parents or anything like that. Can I was just going to go to. I was going to go to the statement of facts and issues.
Yes.
And identify for you, if you go to page 9266, what you can see there is a statement of the issues towards the foot of the page above paragraph 35. Now, these were issues which were agreed between the parties as the issues that were going to be dealt with. And you can see that the first issue relates to concurrent findings. That, needless to say, was an issue which we put forward. You will then find at paragraph 35.2, there are a series of issues. Well, there is one issue, if you like, but with 8 sub-issues to it. Those include: was STIC a quasi-partnership? Was it deprived completely of its substratum? Was STIC's resolution, this is little Roman 3, in breach of an agreement or understanding? So that leads you to the shareholders' agreement and the family agreement. You've then got what was the substantial, primary and dominant purpose. Then you've got section 175, section 59, and a subparagraph about destruction of the alleged trust and confidence, and finally dividends and withholding information. Now, I don't invite you to go there now, but just for your reference, if you go to 9231 to 9233, you will find there, not quite in identical wording, but in it's very close, the issues attached to the notice of appeal that the appellant said were going to arise in relation to this case in the Privy Council. Now, the first issue is said to be whether STIC was a quasi-partnership in the form of a family company founded upon mutual trust and confidence. Now, I would say we have seen that question already, and we have seen it determined by the judge and the Court of Appeal against the appellant. And indeed, if you go to 9255, you will see this being an agreed document. At 9255, there's the first issue. STIC was a quasi-partnership, a fact rejected by both the judge and the Court of Appeal. So everybody agrees that that fact has been rejected. The second issue, back on 9267.
The question whether a company is a quasi-partnership, I mean, very much in line with the submissions you've been making, can't be regarded as determined as a question of primary fact. It's an evaluation in respect of primary facts, isn't it?
That is probably fair. It is probably an evaluation of all the factors that go into, are you a quasi-partnership or not?
In which case it doesn't fall within the practice of the board.
I see. So, yeah, because it's a matter of evaluation. Okay, well then, very well. In relation to that one, we won't be going there. We'll be going down the route of saying, well, were they in a position to actually to reach a decision which a reasonable, were they in a position where no reasonable judge could have reached the decision that this judge reached?
Well, the way it's put against you is there were some facts which were not contested, including that this is a family company aimed at running the family business for the benefit of the family members. And that seems to be common ground. And the question is what legally emerges from that in terms of the creation of equitable considerations which constrain the exercise of strict legal rights.
Yeah, I mean, there were a series of facts. Okay, so there were one or two that were factors which were raised. I'm not sure there was much common ground in relation to a lot of this. I mean, even the word family company is a difficult one because the way my learned friend would like to use family company is much more of a, gives it a much stronger flavour of family than the way that the respondents would like to say it was a family company. I mean, it was a family company in the sense that there were three brothers who happened to be shareholders in this company. Whether that gives you a strong family company or not is obviously a matter of degree. But there are other factors that we could put forward into that pot, and we did put forward. And for example, if you go to 9358 at paragraph 60 of our written case, the first thing we say, this is not a case where STIC took over a business that was formerly run as a partnership or run by the brothers of partnership. That, of course, being one of the factors raised in the famous passage by Lord Wilberforce in Ebrahimi. Our second factor to go with this would be that STIC was incorporated in 1996, as we say at, the reference for that is 2628. As we say at paragraph 60, STIC was incorporated with a 5-page memorandum of association and 18 pages of articles. So we say that you would look at those memorandum and articles and you would say, well, that's a pretty comprehensive set of rules for running a company. You don't need to look elsewhere for running this company.
But all these companies in relation to which equitable considerations are held to supervene have complicated sets of constitutional rules which, if there were no equitable principles, would probably enable the company to be run.
Well, it would be much easier if they didn't have one to enable you to...
It would be much easier for all of us, Mr. Alexander, yes. But alas, the world in which we have to make these decisions is a difficult one.
Yes. Okay, well, then I move on to my next point, which is that neither the judge nor the Court of Appeal found any evidence of the operation...
Just before, are you saying, when you say there are 5 pages and 18 pages... STIC has been described as an off-the-shelf company, but are you saying that actually the memorandum and articles were a bespoke set and there's evidence that the brothers or whoever discussed what should go in there and agreed those, and they weren't just the sort of the leftover standard constitution that the company had? Because I would have thought that if you can show, well, they all got together and agreed this was what was going to be in the memorandum and articles, you would be in a stronger place to say. So then there's no reason to think that those legal entitlements were intended to be constrained by some additional equitable considerations.
Well, I completely understand that, and I cannot say it's anything other than an off-the-shelf company. What one doesn't know, I mean, it is a company which is off the shelf that appears to be directed at holding, in particular in this case, shares and things that are of a similar nature to shares. But what I can go so far as to say is that neither the judge nor the Court of Appeal found any evidence of the operation of extraneous agreements or understandings in relation to this company. Indeed, the judge found that both the allegations made by the appellant, that there was first of all a shareholders agreement, and secondly, that there was a family agreement, both of those the judge found to be untrue. And I'll come back to those in a moment. There is no evidence, at least no evidence that we have, that STIC was ever run in an informal way. Obviously, each of WKN, WKY and WKC signed up to the Constitution as it was when they became shareholders in STIC, as we say.
Well, they didn't. The trustee signed up to the Constitution. They were simply beneficiaries of sub-trusts held by that trustee.
OK, my lord, I've put it too strongly. Yes. As beneficial owners, in those circumstances, they became beneficial owners of a 1/3 share interest in a company that was going to be run in this way, is what I should have said. There's nothing to suggest how STIC would be run with each of the brothers having management roles. There's nothing in the Constitution which places any kind of restriction on the ability of any of the brothers to transfer their shares to someone else. As I said, WKC expressly confirmed in his witness statement that STIC was not run as what he called a quasi-partnership.
Totally contradictory to the articles of realty. The brothers were envisaging that that company would remain a family company, as far as I understand it. And if one of them used STIC as a method of divesting themselves and passing on their shares to somebody else, wouldn't that just be running totally contrary to the position of the holding company in Malaysia?
Well, I understand exactly. I understand exactly why your lordship says that, but on the basis of the provisions, it doesn't appear that there is a restriction on any of the brothers being able to realise, if you like, their 1/3 share interest in STIC, should they wish to do that.
The point was there were restrictions on transfer.
Well, my lady, I don't think there are any restrictions on transfer at the STIC level. So they could transfer, assume they have a 1/3 share.
They didn't.
Sorry?
They didn't. They were beneficiaries under a trust.
What, my lord? OK. Assume that they could call to get themselves to become the legal owners as well as the beneficial owners.
Were they the sole beneficiaries under these trusts, or were they and their sisters and cousins and aunts all beneficiaries with a gift over to charity?
I'll have to have a look, my lord.
It makes a difference.
Yeah, OK.
Because if they were sole beneficiaries, they might have been able to wind up the trust under Saunders and Vautier.
I'll have a look. My recollection is that each of these trusts is a one-page document. But I will ask if somebody could have a look and tell you the answer to that. Now, I mean, we would put it, I quite understand that there are other considerations that you may wish to take into account, but we would put it on the basis that obviously the brothers trusted each other and as such regarded STIC as a family company in the sense that it was beneficially owned by 3 individuals with a family relationship. But we'd say that's not enough to turn what is evidenced, at least at the moment, to be a properly run company governed by a constitution. And we'd say that particularly where one of the people, well, the person who was responsible for actually putting the rules together for this company was WKN. Now, obviously, at no stage prior to WKN's death did the appellant ever have any real involvement with STIC or was involved in any of its strategic, commercial, managerial or other decisions. And we also obviously would put forward that the position is that there's not a single letter, email or document which supports the notion that this particular company, STIC, was in fact a quasi-partnership. Now, the important thing from my perspective is, on the basis of that, we say, given those all of those factual matters, when the judge goes and concludes that, as a matter of evaluation, that there was no quasi-partnership, we say it is impossible to say that he reached a decision with those factors being in existence, which no reasonable judge could in fact have made.
We have to bear in mind, don't we, that he also thought that it would be unfair to leave the appellant without a remedy. Now, what consideration? I mean, the constitution of STIC didn't afford any remedy to the appellant. So, what considerations was he taking into account in reaching that conclusion, which led directly to the remedy which he ordered?
Well, my Lord, I can't answer that question because there's nothing in the judgment that actually says anything other than effectively what your Lordship has just said.
Unfair.
It just says he thought it would be unfair to leave her in as a shareholder and therefore ordered that WKY and WKC should buy her out, yes.
Would it be unfair to leave in an ordinary shareholder as opposed to a family shareholder having mutual trust and confidence in each other?
Well, Lord, I think the answer to that is it depends on, as a judge, on how sympathetic you feel to the person who is actually there with a one-third interest.
Well, surely judges operate on a slightly more sophisticated basis than that.
Well, I mean, look, my Lord, I can't go so far as to say any more about this because the judge hasn't given any indication. It is in one paragraph in the judgment after he's decided that there is no unfair prejudice. So it's not as if he's sort of turning around and saying, well, I decide there's unfair prejudice, therefore I'm going to give you this. What he's gone so far as to say there is no unfair prejudice, but I'm still going to do this. And I mean, you know, obviously we can come on in due course as to, you know, our position in relation to that was when he decided that, it seemed like quite a sensible remedy in this particular instance.
Whether or not he had jurisdiction to want it.
My lady, I wasn't going to go into whether he has jurisdiction or not to do it. I think if one looks at it, the natural inclination would be that you needed to find unfair prejudice before you can go down the route of saying, I'm going to grant a remedy. But the problem doesn't really arise because what happened as a result of that was we said, okay, well, we'll live with that. When an appeal was put in by the appellant, she challenged whether or not there was unfair prejudice. She did not say, in circumstances where there is no unfair prejudice, I wish to challenge the judge's decision, even if it was a decision made without jurisdiction. She did not go down the route of saying, I wish to challenge that. And at one level, it's not a major surprise, because one of the remedies which she actually sought was a buyout order. And so...
But you say you can't reverse engineer from that remedy a different finding on unfair prejudice from the one expressed by the judge earlier in the judgment.
I absolutely say that, my lady, yes. I mean, my lady, we put it the other way around. I mean, he obviously went very carefully through what amounted to a lot of allegations of alleged unfair prejudice. He went through and he found all of them not to be proved. Having done that, he then went on and said, I'm going to make an order that you buy out the appellant. Now, as I say, I mean, you know, at the end of the day, we didn't challenge that, and it wasn't challenged by the appellant. Indeed, so much so that in the Court of Appeal, I'll get you the reference in due course, the Honourable Justice Mendes asked my learned friend Mr. Crowe the question of, well, what happens about this order if we find there is no unfair prejudice? And my learned friend said, well, in those circumstances, the order will stand. So there you have a situation not only of us turning around and saying we'll live with the buyout order whether it's legal or not, but you have the appellant turning around and saying, I'll live with the buyout order if it's legal or not.
That's not her preferred position.
Well, it's now not her preferred position, but it's better than nothing.
Yes, I just meant in front of this.
It's probably probably the way of looking at it from her point of view is it's better than nothing to get out, but my preference would be a winding up order. I'll come on to the winding up part of this in due course, because we say it really would not be a good idea at all to go down that route. Indeed, we obviously say that unless and until you can find unfair prejudice, one can't go down that route.
So why haven't you challenged it then?
Why haven't?
But you've not challenged this.
Challenged the
buyout order?
No, we haven't. Because in circumstances where, okay, we can live with that, that is one way of dealing with the problem. And as I understand it, the position from the appellant is essentially exactly the same. If there is no unfair prejudice, well, I want the buyout order too.
Your essential point, coming back to quasi-partnerships, is that this was within the remit of what the trial judge was entitled to decide, and that's been confirmed by the Court of Appeal.
Yes, my Lord. Exactly. And that's going to be the same in relation to quite a lot of these other points coming up, even if you haven't got a situation where the concurrent finding principle is actually applicable. So you start with, is it applicable? If not, move to trial. Was this something which no reasonable judge could do? And I would say, on the basis of the facts that I've indicated to you, perfectly within the judge's remit, having heard the witnesses, to take a view that this was not a quasi-partnership. And that you couldn't say that the only view he could ever come to would be that there was a quasi-partnership.
And there you're using the term...
I'm sorry, my lady.
There you're using the term, was there or was there not a quasi-partnership, as meaning the same thing as were there or were there not equitable considerations that constrained the exercise of legal rights within the constitution of the company.
Yes, my lady. I mean, I'm using quasi-partnership as a shorthand to mean exactly what you've just said. Okay, the trust deeds are at 3703 to 3705. From memory, each is a single page. I think they're bare trusts.
Oh, it's a nomineeship. It's not really a trust.
Yes.
Well, it says it's a nomineeship and a trust.
I think it says it's a trust, but
anyway, quite clearly the beneficial owner is in charge.
The beneficial owner is in charge.
Yeah. Thank you. Very helpful.
and there is an express right to call for the share. Can I then move to substratum? Now, and the reason I moved to substratum is obviously because that is the second issue raised in paragraph 35.2 of the agreed statement of facts and issues. So the second one was, has STIC been completely deprived of its substratum? Now, obviously, the first thing we'd say is that the Court of Appeal and the judge have found, as a matter of fact, that STIC did not lose its substratum. But even, but going beyond that and saying, well, can you reach the situation where the judge's factual conclusion was one that no reasonable judge could have reached? We say that obviously the judge wasn't wrong at all, but we also say that the judge certainly did not reach a view that no reasonable judge could have reached.
Treating it as a mixed fact and evaluative question.
Exactly,
Yeah.
as in relation to the quasi-partnership point.
Yeah.
Well, there's two questions there. What was the substratum? What was, and then was it lost?
Yes, I'm going to come on to a series of facts which I hope will help. I mean, our starting point here is like both the judge and the Court of Appeal, that you have a memorandum of association, and that's set out at 9361 in paragraph 75, a series of objects, and we say that just looking at that, those objects are plainly wide enough to cover STIC converting the CPS into shares in WTK Realty and holding those shares instead of CPS. Now,
well, the objects couldn't be wider. Any other business or businesses whatsoever. But isn't the substratum question is normally asked in a rather more it's normally asked by reference to the real purpose rather than the torrential purposes in a widely drafted memorandum of association, isn't it?
I mean, my Lord, I understand exactly why you say that, but in this instance, I would go so far as to say, look, it's very obvious what the purpose of this particular company was. It was to hold the CPS until it chose to change them into shares.
Or to put it even more simply, to hold convertible CPS.
Well, yes, but then assume that it converts the CPS. Yes. It's perfectly okay to hold what it's converted it into. Yes. I mean, the appellant describes it in a slightly different way, and that's why I just did it in a slightly different way with your lordship. The appellant says that STIC was a single-purpose company whose sole function had been to hold the CPS. Now, I think what's intended by that is you have the power to hold the CPS, but you don't have the power to hold the shares, if you like. Once you've got rid of the CPS, your substratum has gone.
Yes, he didn't put it in terms of power. He's simply saying it's there to operate as a means of offshoring profits. That was its purpose. That worked perfectly well while it held CPS, but it doesn't work if it holds ordinary shares.
Well, that's what they say, yes.
Yeah.
Yes. I mean, we say that, I mean, your lordship's pointed out is extremely wide, but obviously the wording of the memorandum, it actually in reality doesn't restrict STIC from doing anything. And indeed, it expressly empowers it to hold shares, stocks, and options. Now, we then come to the submission that whether STIC was a single-purpose company whose sole purpose was to hold the CPS, we would say just simply does not accord with the facts as presented in this case by even the appellant. If you go to 205, I hope you will land on paragraph 9 of the appellant's re-amended statement of claim. And you'll see that in paragraph 9 she says this: the company was incorporated for the purpose of improving the tax efficiency of the family's interest in WTK Realty, defined below, and to procure financing for WTK Realty. So here you have the appellant quite clearly herself saying that the sole purpose of STIC was not just to hold the CPS. And this is a document, of course, which has a statement of truth carried by the appellant at page 219. So there we are. We can see two other, if you like, purposes described that are alleged to be the purpose of of STIC. And you get the same from the judge at a paragraph we looked at earlier, which is on page 224. I think it's at 14. Sorry, 224 is...
No.
I'm sorry, 224... I'm just going to get there. 223. It's going to be...
We're still in the pleadings.
It's going to be MS39. And I'm hoping there's a paragraph 14 there. Yes. This is the judge's judgment, where he records, according to the claimant, the company was incorporated for the purpose of improving the tax efficiency of the family's interest in realty and to procure financing for realty. According to WKY and WKC, it was WKN's idea to hold a special category of convertible preference shares with a par value, which were issued in due course. And then, if you then go on to 1180, you reach the appellant's witness statement, and at 1118, at paragraph 32, you there see that the appellant actually says that STIC has only ever existed for the purposes of holding shares in WTK Realty. So it's not even the CPS. On this occasion, we've got the appellant saying that, in fact, the purpose of this company was to hold shares in WTK Realty. So
I'm so sorry. Paragraph 32.
Paragraph 32 on page 1118.
Oh, I'm so sorry. It's oddly enough, 1188 also has a paragraph 32.
Yeah.
Thank you. I've got it.
So here you have the appellant actually saying what it is that, well, is actually happening now.
Well, does that one really help you?
Well, my lady, I mean, all one can do is point to the fact that there are these inconsistent ideas as to what this company was intended to do. One of them is to hold the CPS, and another of them is to hold shares in WTK Realty.
But as far as this tax efficiency and the loss of that may be if the CPS are converted, my understanding from what we heard before was that there's nothing written down by anybody to say that that was the purpose. One just assumes that the reason why one holds the shares in a BVI company is something to do with tax efficiency. Is that fair?
I do not believe there is anything written down to help us from a contemporaneous piece of paper or anything like that. I will double check overnight, but I don't think there is.
somebody has actually asked the accountants who were involved in this to produce their files, have they?
Well, your lordships raised that question a little earlier. And
I did.
I will ask.
Yes.
I can't give you an answer.
Yeah. Because it would
Standing.
presumably have been done at the instigation and being paid by Realty, and Realty is now under the control of your clients.
Hope not, that would be a breach.
Well, it's pointed out to me 25 years ago.
I know. Appreciate that.
You know, we don't know, but I mean, I'll see what we can do to get you an answer.
That seems to suggest they haven't been asked.
We do know that the company was not bought off the shelf, but was formed by Ernst & Young, who were the registered agent and also share the same address as Gainesville.
Yes.
So it's all, looks very like a tax scheme.
Yes. Well,
But if there were such documents, they should be available.
well, I mean, yes, if there were such documents and Ernst & Young continue to keep things from 25 years ago, I just don't know whether they will. I mean, I could quite understand that you'd expect a company now to keep documents and to have them accessible, you know, electronically, but back then, whether you would do that, I just don't know.
I don't think we're asking you to ask Ernst & Young now. I think we were asking whether there were any documents available at the hearing.
Well, I'm going to ask, yeah. I mean, now, I think actually, even in the transcript from today, I've got a feeling that my learned friend said that the purpose of this was to hold shares in WTK Realty himself, rather than just the CPS. Anyway, the simple fact on that, all of that, is we say that you can't fault the judge from coming to the conclusion that STIC had not lost its substratum on the basis of the facts which I've just been through. The next, and this will probably be the last one we get to, in fact I might not even finish it today, the next point is that the appellant then says that by the conclusion of the trial, STIC had lost its substratum because Realty had been wound up in Malaysia.
Well, I think ordered to be wound up.
Your Lordship is absolutely right, ordered to be wound up. On the very same day I was going to come to, the decision in relation to Realty literally happened on the last day, the day on which my learned friend was doing his closing submissions in the morning, and I think I had to do mine in the afternoon. It was the 6th of November, so obviously it was very new news, if you like, on that particular day. Now, obviously, an appeal in relation to the winding up order in respect of Realty was bound to follow. It did, and the winding up order was stayed and remains stayed pending the outcome of the appeal. The appeal has not been heard and won't be heard, I think, until February next year. But whatever the result, I should tell you that, subject to the obtaining of leave, there is another rung on the appeal ladder to the federal court in Malaysia. So the decision on the appeal is therefore likely to be appealed upwards by whichever party loses if
they can get permission. It's not without leave, is it?
If leave can be obtained.
Yeah.
If it can't be obtained, then obviously it won't be able to go up. So we say that, you know, at the time of the trial, and by the time of the Court of Appeal even, there was no certainty as to whether Realty would remain wound up but subject to a stay. Well, it would probably actually would in fact be wound up with the stay being lifted. Given there are 2 rounds of appeals to go, obviously we say even now there's no certainty at all as to whether the winding up order in respect of Realty would remain. In any event, we would say that the mere fact that Realty was placed into liquidation, did not cause STIC to lose its substratum.
Well, didn't it?
Well,
I mean, it put a pretty clear end to the substratum in the sense that the process of the liquidation of Realty would mean that holding shares in a company that's been wound up and dissolved is a rather sort of non-continuing exercise.
Well,
in reality, STIC would get paid out for whatever those shares were worth in a probably very solvent liquidation and be sitting there on a pile of money as its only asset.
We would say, obviously, that at the moment in question, STIC would continue to hold 14.4% of those shares. And as a calculation just for you, that's 36 million worth of US dollars on the basis that the appellant accepted that the group had total equity of more than 250 million US.
But, I mean, can I just check this, Mr. Alexander? You may want to answer it tomorrow. Assume that that Realty was wound up, i.e. that the appeals are either abandoned or failed, and assume for the moment that there was a cause of action or some reason for the court to have discretion whether to order a winding up of STIC or a buyout. Do you submit that a buyout would have any logic in the context of STIC becoming, at the end of the winding up of Realty, simply a company holding a pile of cash in lieu of the shares?
Well, my lord, I was going to come on to a not dissimilar question, which I'm sure I can roll that one into.
All right.
But I think your lordship might be right, that it might be better if we do that.
I'm perfectly happy to answer, but I would like, and it may take some thought, because it's not one that jumps off the page at you from the statement of facts and issues.
Happily, my lord, there's a transcript, and I shall remember to look at the very last page, and I shall get that one out, and I shall deal with it myself.
The transcript of what?
Today.
Today. Oh.
Yes, well, thank you very much, Mr. Alexander. We probably run you into the ground.
No, not at all. I mean, I would happily go on for hours, but I don't think...
No, I think we'll continue tomorrow at 10:30.
Yes, my lord.
Then you'll get probably an extra 5 minutes beyond the previously agreed 12:30.
I'm slightly unsure where I've actually got to in overall terms, because I've been picking things up and doing them. So I suspect we'll find quite a lot of what I think is still to come is not.
Good. Thank you.